Welcome to this afternoon's session. Thank you for coming in and ignoring the delights of the sunshine and St. James's Park, and also the other session. But if anyone isn't here for Copyright What Next, then make your excuses and leave now. Copyright What Next is a very good question, I think, as we've heard reference to this morning, and it can be understood, I think, in two ways. One is what will be done to copyright next. It's become something of a commonplace to say that in the digital marketplace, copyright has gone from being behind the scenes to becoming an issue, and therefore there's something has to be done. There's few sensible people, I think, who would say that there should be no reform of copyright. There are no sensible people who say copyright should be abolished. But between those two positions, there are, of course, a range of stances one can take, from the incremental reformists right through to the radical revisionists. So we'll find out if any of our panel are on either of those positions in a moment. But the other thing the question asks is, what will copyright itself do next? In other words, what new licensing structures, business models, products and services will be generated by and derived from the IP framework as it currently stands? So those two questions are linked, I think, because if copyright can do stuff next, then maybe those people who want to radically reform it, they don't need to, because we have the solution in our hands. Anyway, so here to discuss that with us and other issues are three people really at the coalface of copyright. They're the ones holding the diamond tip drill into the seam of copyright. They are Sarah Faulder, the Chief Executive of the Publishers Licensing Society, Michael Healy, the Executive Director for Authors and Publisher Relations of the Copyright Clearance Centre, and Stefan Busch, a member of the editorial team of BioMed Central. So to kick off, I'm going to ask each of them in turn just to give a 2-minute top-line response to the key question, copyright what next, and then we'll enter discussion. And please do start formulating questions for the panel, because there will be time for that towards the end. So Sarah, can I hand to you first, please?
Thank you, Richard. I'm in the camp that believes that copyright does have a future, and so it will continue. I mean, the inescapable fact is that copyright has adapted quite successfully over 300 years, so why should it not continue to do so? We do have a slight problem in that the law moves incredibly slowly, and technology just moves faster and faster. And so the time lag between the two, the law keeping up with the technology, is just growing. But in the meantime, at least, industry has shown that it is able to adapt. It's painful, it's slow, but it is adapting, and the law is adapting. You could say that digital is a game changer, and then, you know, why do we need copyright in the digital age? But I would say, well, why should the fundamental rules that govern copyright have to change completely? To take an analogy, we've got the highway code. Now, just because you get faster cars with wider roads, with more lanes, more faster motorways, doesn't mean to say that you have to abandon the rules of the road. On the contrary, they need to be adapted. Speed limits are changed, they're increased, but you still need those speed limits. You cannot ride roughshod over everyone else using the roads, just because you can do it, just because your car can go faster. You need different rules. You need more about lane discipline, keeping your distance, that sort of thing. And that's what we need to be looking at with copyright in the digital age. Copyright can use technology to help apply the rules. We can have metadata all about rights ownership and rights licensing to help copyright along. We can also enforce it. So here we are, a couple of days' time, we've got the Charles Clarke Memorial Lecture, which I hope many of you will come to. And of course, Charles was famous for saying that the answer to the machine is in the machine. So I think, you know, copyright coupled with technology can work going forward. My third point is that I do believe copyright has an image problem, and that is something we need to do something about. It's partly because the very word copyright is not understood, it's very misleading, it's very complex, and copyright is perceived as being very long. It's something you can't explain in sound bites, and we live in a world of sound bites. You know, it is complex. You have to explain it in order to justify it. And this problem has become more acute because copyright has become a consumer-facing issue in the way that it never used to be. You used to have intermediaries. The broadcasters would take care of the copyright licensing behind the scenes. Now consumers are faced with it on a daily basis when they download from the internet. So I think we need to look at copyright in a more positive way, understand that it is a positive force, and turn it to our advantage and use it to support everything else that we're doing in business.
So thank you very much. Michael, copyright, what next?
Well, it's interesting to me that a conversation of this kind probably wouldn't have happened even just a few years ago at a conference like this. As Sarah's implied, copyright has become front-page news in recent years. And, you know, I'm certainly in the same camp, and no surprise there, as Sarah, that copyright has an important future. But there's a paradox in a way. Here we are sitting, a few hundred yards away from the Palace of Westminster, where 303 years ago this week, the Statute of Anne was first enacted, the first real proper copyright law. And ever since that act was put into effect, you know, copyright has been playing catch-up with the evolving technology of the day. Whether it was the emergence of photography in the mid-19th century, whether it was recorded sound or transmitted sound or piano rolls, you know, there have been multiple copyright acts in various jurisdictions ever since, and many of them have ironically said that they are sort of the last word on copyright. But almost before the ink is dry on legislation these days, new forms of content dissemination make copyright out of date. And there is this sense of copyright playing catch-up, whether it's with mass-market software or video games or whatever. I don't take the view, as my friend Richard Nash said in one of the earlier sessions, that the demise of copyright law is inevitable, just as other ridiculous laws like stopping horses pooping in the street, I think was the expression he used. Frankly, that is horse poop. It will continue to be, in my view at least, a cornerstone for the development of a healthy digital economy. And the paradox, I think, is that despite its importance and significance, it is under remarkable threat right now, in many ways. If you want to see this threat in action, go to Canada, where the Copyright Modernization Act of 2012 is now in place. And whatever you think of that piece of legislation, if you know it at all, one thing is clear. That is, it's being interpreted to mean that all copying is fair dealing in schools and educational establishments for free. And the licensing revenues earned traditionally by publishers in Canada is going to go through the floor this year and next as a direct result of that act, and as a direct result of how establishments are interpreting that act. And if Canada were the only place that was happening, then it would be a localized issue, but it's not. There's scarcely a week goes by where some government around the world doesn't carry out a fundamental review of its intellectual property regime, whether it's patents, trademarks, copyright, whatever. There's nothing wrong with reviews of that kind. But we seem to have quite quickly got to a place where copyright has moved from being an essential cornerstone that protects the investments of content creators, and therefore a critical part of a flourishing digital economy, to the point we've got to now in some countries where somehow copyright is perceived as a threat to the flourishing digital economy. I'm not sure why that has happened, and it's happened so quickly, but it's a worrying trend. So I think copyright has a future. I think it has a vital, flourishing future, but we do have to address many of the issues that Sarah has raised about how it's perceived and understood. And the one plea I would make to all of you, if you are owners of content companies or working in content companies, take this seriously. If you think it's irrelevant to your businesses, you're wrong. It is one of the fundamental building blocks on which the content industry rests. And it's a foundation stone that is wobbling right now, and it needs the support of everybody in this room and everybody in this industry, in my view.
Michael, thank you very much indeed. And we have a new phrase for our lexicon. We can say anti-copyright arguments aren't BS, but HP. I'll be using that one. Stefan, if I can change the question around a little bit and say, what next for copyright?
Okay. I guess I'm the open access person on this panel, which immediately leads to two questions. One is, why me, especially on such a nice day? And secondly, is there any direct relationship between open access, publishing, and copyright? Now, I can't talk about copyright, really. In this sense, I'm misplaced here, because I'm not qualified. And fortunately, as far as I can see, I don't have to, because I don't see why open access publishing actually needs to change the fundamental framework for copyright. Neither can I talk, and I'm assuming that many of you are in the book publishing business, and I can't talk about open access to books, which is a tiny market. There are some experiments with that, but I think we can confidently say it will remain tiny for quite some time and only become relevant in some very specialized markets. So what I'm really talking about is only open access licensed content in academic/scientific journals. But this immediately leads us to a question that is at the core of the open access debate, and that is, what is the right or the optimal or whatever license for open access publishing? Now, the most liberal Creative Commons license, the CC BY or Creative Commons Attribution license, has become or is becoming, quickly becoming the standard for open access publishing, not least because it is more and more a requirement from research funders. So CC BY, meaning that, in a way, amateurishly, I often say it means anything goes as long as you attribute what you're doing to the source in academic circles, meaning citing the article you are referring to. The only serious contender I see for CC BY, so for the most liberal license, is the more restrictive CC BY NC, so non-commercial license. And I don't have the time here to go into the details and the arguments pro and con. This is simply not the time. I've got about 30 seconds left. So all I want to say, therefore, are two bold-ish statements. One is hundreds of thousands of articles have by now been published using the CC BY license. There is no problem. That in turn means that the onus is on these people who argue for more restrictive licensing, in practice usually CC BY NC. In fact, what we will see more is even more liberal licenses, if that's the word, especially CC0 for data. But whether this is a license or not is probably something I can leave to the experts to discuss. But this is very discipline specific, and therefore leave this point immediately. One, being a humanities person who somehow ended up in biomedical publishing, Something that interests me personally is the question whether those have a point who argue that CC BY is not a good, suitable license for outside of STEM publishing. I must say, I haven't really seen a convincing argument. I suspect it's driven by worries and fears, which don't really have much substance, but as there are worries and fears, they are real, and they have to be dealt with and answered. Full stop.
Thank you, Stefan. Thanks very much. Thanks, each of you, for those fascinating initial thoughts. I'd like to go into the debate. Perhaps, first of all, come back to you, Sarah. As I said at the start, there are ways which copyright is already reforming itself, and PLS is very deeply involved in at least one of these, which is the Copyright Hub, which you referred to in your opening remarks. And Richard Hooper, could you say a bit more about what publishers could get out of this initiative?
I think it's terribly important that we make life as easy as possible for people who want to get access, legitimate access to what is being published and made available. And the thrust of the Richard Hooper Copyright Hub is to streamline licensing and try and help steer people through the complexities of the world of copyright licensing, which are, there's no question it is a complex world. So if by getting behind the hub and supporting the hub, it will help the industry enormously in terms of PR, in terms of showing that it is progressive, it is able to move with the times, it is recognizing the difficulties that people may have by enabling the work of the hub to proceed. So it's just crucial, I think, that the industry does support this hub.
And Michael, the CCC is involved in this as well. So why is an American collecting society getting involved in a British initiative?
That's a tough question to answer. I sit on the Copyright Hub launch group, and I think I'm the only representative of a non-British organisation. I suspect it's because of my charm. I have no other reason to know why I'm on it. But the critical point, I think, is the one Sarah made, which is when I look at Richard Hooper's initiative, from the distance of 3,000 miles, perhaps the most significant element of it is it's a really important demonstration to government that the creative industries, not just text publishing, but music, still images, moving images, etc., can get around a table and get their own house in order. And Richard, you and Sarah have been instrumental in pushing forward this entire conversation and initiative. And it seems to me that is vital. Something similar is vital in every developed economy, because we do not want to leave it exclusively to be a conversation between regulators and pressure groups. It's a demonstration that this industry appreciates that licensing today isn't perfect in every respect, that copyright is not perfect in every respect, and that we are listening as an industry or a set of industries to the concerns of those preoccupied with these issues. And I think that's the lasting significance of Hooper's work.
And Stefan, to come back to you, we heard this morning a familiar sort of debate you get around copyright in publishing, which is, let's look at what happened in the music industry and then see if it's going to happen in publishing. But it often seems to me that academic publishing has got as much to tell trade publishing about licensing and copyright, because you've been there at the coalface for a great many years. So what would your message be from the perspective of an academic publisher? Should people lighten up more? Should we get CC BY licenses more widespread in trade publishing?
Open access has nothing to do with a free-for-all. And this was not a point that I had to talk about here. No. But the business model is different. So it's not based on subscription. We, meaning BioMed Central, Springer, etc., in its open access branches, we get paid for our services, and it works. And not only we, it's other publishers, PLOS, Hindawi, others as well. So the business model is sustainable and has great potential and future. So that's why I didn't touch upon it, because I took it for granted that, yes, it does work.
But do you think, and for those non-academic publishers in the room, just to fill in, there's this notion of gold open access, whereby the author of an article pays the publisher to have that article published.
Yeah.
Could that ever happen in other areas of publishing? Is that always going to be an academic publishing practice?
Well, it does occasionally happen, but I don't think from a business perspective this will be of much relevance. The starting point for academic journals is that authors have traditionally always given this content away for free, right? It's not that a researcher at a university, when he has an article and submits it to a journal, expects any payment. And that's the starting point, and that is different from book publishing or other publishing areas. And that is actually underlying the whole licensing question, or separate from that.
Sure. Sarah.
But I think research authors are also to be distinguished from other authors, because they are working with grants, they are funded to do their research, and therefore they're being paid in a different way. They're not dependent on royalties from sales.
Yes.
Michael, if I could come back to you, we have an international audience here, and all of us in the UK, I'm sure everywhere around the world, look very closely at what goes on in the US, and it pretty much always has an implication for us one way or the other. There have been a couple of US court judgments in recent months, one to do with the parallel importing of academic education books, and another to do with the resale of digital copyright. Yes. The Kurtzsang and Redigi cases, for those who may be familiar with them. Can you say a little bit about those and what you think the impact is for publishers everywhere?
Yes, the two cases you refer to were judgments that came hot on the heels of one another very, very recently. The Kurtzsang one you refer to was a Supreme Court judgment, and therefore very, very significant. And essentially what it said was that the importation into the United States of foreign editions published by publishers such as John Wiley, who was the plaintiff in this case, the reimportation and the resale of those within the domestic US market was legal. And that was a very significant statement on the doctrine of first sale. And then a much lower court, a New York court, I think a week or two later, in a case involving Redigi, a company many of you will know, said that it was illegal for a consumer to resell a digital file through a service like Redigi. So I don't think the two of them, those two cases, have much in common other than the resale element. One is strictly about reimportation and resale of physical books, and particularly academic and textbooks, and the other one was the resale of digital files. But I think, again, the significance goes back to what I was saying a little earlier, which is that in the US particularly, where case law matters so much, judges are, in their view, clearing up the mess that the existing legislation fails to address. Now, Congress in the US hasn't had a new Copyright Act since '76. There's much talk that there will be. The Register of Copyrights in the US, Maria Palante, has announced that she wishes to proceed with a new Copyright Act. But however good it is, and I'm sure it will be excellent, my other point earlier applies, that it will be out of date, and it will create areas of uncertainty that judges will have to resolve going forward.
Thanks, Michael. And that potential for revision of copyright at a parliamentary level is something where also facing the prospect of in the EU. And Sarah, as you know, there are working groups going on. Can you perhaps fill people in a little bit on some of the process with the Commission and what publishers are trying to achieve with their engagement with it?
Yes, at the moment, English law and that in other member states is governed very much by the European Copyright Directive of 2001. And there is pressure on the European Commission to reopen that directive and have a look at it once again. Unfortunately, some of that pressure seems to be coming from our own government in certain areas. But so at the moment, there are some so-called stakeholder dialogues proceeding through this current year, bringing together all the parties, looking at very specific issues from user-generated content and how that should be managed and licensed to text and data mining, whether that can be managed through licensing or, there are those who are pressing very hard for an exception to copyright for that, which again we're defending very hard at the moment. So there's constant pressure to review and reform, and that is a moving target, and I think we'll sort of know early next year whether that directive is going to be reopened. But in the meantime, there are shouts also in the UK for a new Copyright Act, just as Maria Palantes is suggesting in America, because our Act dates back to 1988, and it's been so amended and adapted and changed with all the European legislation that's come through and with the whole digital evolution that it's difficult to follow it through sometimes because there's so many bits that have been added on. So we could do with certainly a consolidating act, if nothing else, but our government isn't minded to make parliamentary time for copyright at the moment, so I can't see that happening in the near future.
Thank goodness, one might say. We'll have 5 more minutes panel discussion, then I will have 10 minutes to invite questions, so please do have them brewing. I wanted to touch on infringement, if we could, though, briefly. And, Stefan, it seems in the academic world, especially with regards to online journals, that infringement doesn't seem to be a massive problem. That it happens, I'm sure, but it seems somehow publishers have managed to keep a lid on the problem, and it isn't really hitting revenues in as meaningful a way as it has in film and music. Why is that? Is that right? And what have academic publishers got right there in terms of preventing infringement?
So you expected me to talk about both for the open access and this traditional subscription model. I think one major factor is that what infringement or plagiarism, these issues are not usually dealt with in courts of law. They are a cultural norm. If you, as a fellow researcher, are caught plagiarizing, that may ruin your career. So therefore, there is an inbuilt social norm to actually play by the rules, and I think that is a major factor here.
And in terms of the provision of, so the illegal access to repositories and people providing links to your content through illegal sites, that doesn't seem to be a massive problem, although it goes on a bit.
Yes, but the users in that area, I mean, if a patient or someone whose family member is ill gets illegally access to something that has been published in a subscription-based journal, it's not quantitatively, it's not really a matter. If that person who actually has accessed that content illegally then uses it, that is a different matter, and again, then probably more social rather than legal norms apply.
Yeah, and this question of members of the public getting access to to medical, in that case, research. Sarah, there's a great bit of work underway at the moment, which is relevant here, isn't it?
Yes, some of you may have heard about the Finch process that reported last year, and this was a drive for making publicly funded research available on open access. And there's a lot of work going on behind the scenes on this at the moment. But the publisher's response was, one thing we will do is to make journal articles available for free to anyone who walks into a public library in the UK. So this is a huge opening up to the public for the very reasons that Stefan outlined. You know, if a family member has got some disease and you want to read up on the latest paper on it, then you will, later this year, we hope it's going to be launched, be able to go into any public library and sit at a terminal and look up that article and ask for a copy of it. And PLS is very much the linchpin in this process. We're developing the license, the technology interface, and encouraging the publishers to join in on that initiative.
So as with the Copyright Hub, another great example of how existing copyright framework can be used to increase access through the use of licenses. Okay, we have 10 minutes to go. I hope that the room is brimful of potential questions. I don't know if the lights are going to come up, but it'd be great if some hands went up if anyone has any question for the panel. Laurie, down the front here.
Thanks. My name is Laurie Kay. Interested to hear your views. Picking up, I think, on the point you mentioned, Richard, about a comment made in one of the earlier sessions about copyright being dead. But there's also a sense of like a disconnect, because I'm sure those of us here in this room that work in copyright, that make their livings from copyright, like I do as a lawyer, don't need convincing. On the other hand, when we hear, which is true, the trend away from direct licensing of content towards the provision of services, where there isn't an obvious relationship between the content that's provided and the payment for that content. And people say, well, if it's all service-based and the content's just part of a much bigger service, really sort of copyright will sort of fade away because we're getting treatment. And there's a real flaw in that. And I wonder whether you think that the flaw is because we're not making the connection, and our colleagues on the product development and marketing side are not making the connection between, even if it's an indirect relationship, that service still has somewhere wrapped in it some form of license. And I wonder, sort of related to that, have we as an industry missed a bit of a trick because we've let Creative Commons, who have a range of licenses, as Stefan, if you like, have sort of free play of the license space in that area? And do we need, as an industry, to develop, rather as you've been talking, Sarah, about the Copyright Hub initiative, more licenses, things people recognize as licenses that we, industry, has developed, whether through APIs? Is there a failure to make that connection? Do we need to make that connection? Do we need to provide some additional tools, especially for commercial rather than non-commercial licensing? Thanks, Laurie.
Who wants to take that on? Sarah?
Well, I would say we don't really want to have to trouble people with, as people say, what's under the bonnet. I think as long as we can make it work, we all know that copyright is absolutely crucial to have at the heart of it. And if you don't have rights of copyright, then you've got nothing to license in the first place and nothing to base your service on. But I think it's incumbent on us to sort that out underneath and behind the scenes and make it as easy as possible for people who want the services to get access to them.
Stefan, you wanted to
specifically for scientific journals, I think the Creative Commons license actually, yes, have done a wonderful job. They have, if you want to just fill that space, I think that was your expression. And there is actually a problem now with more licenses, because the more licenses you have, the more complex it gets, and what the research communities want is simplicity. They want to know what rights they have, for example, for data mining, etc. And the more licenses you have, whereas a bit is allowed here but not there, etc., the more complex it gets, and you will actually run into a wall there. And it will largely be ignored, I suspect, if you make it over complex.
Michael, did you have anything to add on that?
I find very compelling the notion we heard in a previous session that you referred to, that the role of a publisher moving from content provider to services provider. I find that idea compelling in many respects, but at the heart of any future services they provide will be content, original content. And as I said earlier, copyright remains fundamental, in my view, to the provision of that content.
I'd love to hear if there are any sort of dissenting voices in the room. You've heard a pretty solid line from the panel that copyright has a future. It isn't facing its demise. Is there anyone in the room who would like to challenge that notion? Even if you don't really mean it, just play devil's advocate. There is such a... It's Richard from earlier.
I thought I would owe this panel
debate.
the opportunity to amplify a little. What I would say is that copyright sort of functions much like carbon energy. It is absolutely critical to our economy at the present. We can't wean ourselves off it instantly. But eventually, we will have to have other bases, because effectively copyright the logic behind copyright was an analog logic. And in a world that sort of is a post-industrial world, the underlying logic of copyright, which is where the public says, you know, we can't afford to make copies ourselves. It makes sense for us to have other entities, other industries to reproduce it for us, bumps up against the reality that they now actually can. Already the music business, which is an example you guys have cited on a few occasions, has found ways to deal with the fact that the copyright value of music is zero through a variety of forms of licensing for television and radio, for advertising, for merchandise, and generating just as much revenue as the copyright did if we exclude the CD replacement of vinyl blip in the 80s.
Sure. This is more like it. Great. Michael, copyright is an analog form of law unsuitable for the digital age.
I had no idea you were in the audience when I made those remarks earlier. Hi, Richard. Unsurprisingly, I don't agree with you. The fundamental premise of copyright is to give a monopoly limited in time to encourage those who innovate and invest in innovations that otherwise they might not invest in and innovate around without that modest degree of monopoly protection. I don't see, or I don't follow fully, how the move from an analog paradigm to a digital one affects that fundamental point. And I suppose if we were to disagree on anything, fundamentally it would be that I see that continuing to have a very important role, and arguably an even more important role in this very fragmented picture that you correctly say we're all working in right now.
Thanks, Michael. That will continue in the coffee break, that I'm sure. There was another question in the middle here, if you'd like to raise your hand, and then the mic finder can find you. Oh, there's two, my God. Okay, can you give your name?
Zola. I didn't really have a question, I was more just going to comment.
Sure.
I am a content creator and a publisher. We get stuck often in things that we want to make because we can't afford the licensing on the copyright of things that we want to bring into our content creation. We find it very restrictive. I used to run a bar 10 years ago, and the same thing. We couldn't play the radio because at the time we couldn't afford to buy the license to play the radio in the venue. I think part of the change that could come with copyright reform is actually making things more accessible by bringing the price down.
And not to talk about the pricing, but the ease point, Sarah, that is what the Hub is looking to do.
The Hub is all about making it easier. Yes, absolutely. You've said it.
And a question, you have the microphone.
Yes, I have a question. I'm studying this open access and copyright because I'm a publisher. My name is Daniela. I'm from Brazil. In my master's and because I'm a publisher. And I can't see until now the open access theory. Where is the publisher work? Because we as a publishers put a lot of work in the content of an author. We transform the content, especially in the academic business, which I work. So how people in the open access academic is dealing with the lack of publishers' work.
Stefan, would you like to handle that? I think the question is about, are publishers getting fairly recompensed in an open access environment?
Yes. I mean, there is quite a bit of experimenting going on with business models in open access, but the standard model by now, used by the big open access publishers and increasingly smaller publishers, is that authors pay when their articles are accepted for publications. And there are other ideas, sometimes journals are actually, whole journals are funded by a society, a government agency, etc., etc. That can be the case. You can try to bring the prices for authors down, or the funders. It's usually not the authors who themselves go to the ATM and give you some money. It's their funders usually. But you can try to bring this down by advertising revenue or that sort of thing. But essentially, the publisher will have to be paid, not by, but usually through the author somehow.
Thank you. Now, in the words of the two Ronnies, that's all we have time for. So if you could join me by thanking Sarah, Michael and Stefan, and thank you for your attendance.